Hello everyone, welcome back. Today we're going to be looking at two insurrections that happened just before the ratification of the Constitution. One in 1783 called the Newburgh Conspiracy. That happened during the American Revolution, right? That's where a bunch of soldiers in George Washington's army were considering overthrowing the Continental Congress, okay? We're going to talk about some of the details of that. And then there was Shay's rebellion that happened in 1786, okay? And this was basically a tax revolt. And again, we're going to be looking at some of the details in this, and we're going to be considering how this relates to the Second Amendment, which was ratified in 1791, okay? So these two insurrections, all right, happened shortly before the Second Amendment was ratified. And the significance of this is when they ratified the Second Amendment, they were very well aware of these two insurrections that had happened shortly before, and their solution, okay, was not to ban guns or restrict gun rights, right? Because they could have done that, right? You know, when they were ratifying the Second Amendment, they were saying, "Hey, we had this conspiracy that almost caused the Continental Congress to be overthrown in 1783, and then we had Shay's rebellion, just a few years earlier in 1786." And the question is, how did they deal with it, right? When they were drafting the Constitution and ratifying the Second Amendment. And this is very, very significant, okay? So I've been following this channel now called Four Boxes Diner for at least a year and a half. The host of the channel, his name is Mark Smith. He's a constitutional scholar, but he's he's not just a guy with a YouTube channel, okay? This guy is a lawyer that other lawyers and judges listen to, okay? This guy speaks before the Federalist Society. So the stuff that this guy says, there's a good chance, and he doesn't just say stuff, he writes stuff, he has books, and there's a really good chance that the people currently sitting on the Supreme Court are watching his videos and reading his writings, and so this is a guy that they listen to. So that's a reason why you guys should also be watching that channel. Okay, so one of the things I have learned over the last year and a half about the way that the Supreme Court works, right, specifically with regards to the Second Amendment, is they said they're going to look at the text, history, and tradition. Okay, so they look at the actual words that are written, okay, and what did they mean at the time they were written. So, for example, when they see the word well-regulated, okay, in 1791, okay, well-regulated meant in good working order, okay? It did not mean government-controlled. So that's the first thing that they look at, right? The text. The second things that they look at, second and third, is the history and tradition. So what that means, and what I have learned from this guy, Mark Smith, is they look at laws that are on the books and enforced, okay? So they have to be both on the books and enforced in order to be relevant for considering possible restrictions on the Second Amendment, okay? So to give you an example, right, around the time of the ratification of the Second Amendment, okay, you could not use a gun to just murder somebody, right, and then claim Second Amendment right? So you couldn't do that. So that wasn't a valid defense for a gun usage, that, hey, you just had a Second Amendment right. So there were laws on the books and enforced in 1791 that said that you couldn't do that, and you would basically go to jail for, be executed, whatever. Okay, so that's what they mean by 1791. So when looking for possible restrictions that would be allowed, right, or possible limitations on the Second Amendment, it's basically limited to laws, right, that were on the books and enforced that say, hey, you can't do this with guns, okay, or you can't have this type of a gun, or you can't have, you can't use this type of ammunition, you can't have so many rounds on you, you can't buy this, you have to get a background check, whatever. It has to have existed in 1791. And in 1791, there were very few, gun control laws. So this works very much in our favor, okay? So one of the things that the anti-gunners try to do is they try to shift this forward to 1865, 1866. Basically, they try to shift it forward to the time period after the Civil War, when the 14th Amendment was ratified. And the significance of that is that after the Civil War, the states passed a lot of gun control laws to try and prevent the newly freed slaves from getting guns. Okay, so there are gun control laws that exist on the books and are enforced after the Civil War. Okay, so that's not good. You have to actually go back to the ratification of the Second Amendment in 1791. So one of the arguments that the states will make is that they'll refer to the 14th Amendment. Okay, now the significance of the 14th Amendment is that prior to the 14th Amendment, the Bill of Rights only applied to the federal government. Okay, so it wasn't until the 14th Amendment was ratified that now all of a sudden everything that's in the Bill of Rights now applies to the states as well. So a lot of the anti-gunners will say, hey, the Second Amendment does not apply to the states until after the Civil War, and hence those are the laws that we're going to, those are the laws that are on the books and enforced that we're going to look at. But that's not the case. That's not the proper way to do it, and that's not the way that the Supreme Court historically has looked at other other things in the Bill of Rights. Okay, so they have to go back to the actual founding. I believe the cutoff period is, I think, 1826, because that's when the last founding fathers were basically dying off. Okay, so that's kind of like the backdrop. Let's go back and look at these two things in detail here. So 1783 Newburgh conspiracy. Basically, the soldiers in George Washington's army were really pissed off at the Continental Congress because they were not getting paid, they were not being supplied, and their pensions were in question. Where basically they wanted a pension that after they left service, they wanted to get paid for a certain amount of years, after their service. So the Continental Army was basically ignoring these things. And what they did is a lot of soldiers got together and they said that they were going to do one or two things. They were either going to just abandon the effort and just go home, or they were actually going to march on the Continental Congress and forcefully get what they're due. Okay, so this was stopped by a speech by George Washington. Okay, he made a very passionate appeal to them. And from what I hear, a lot of the soldiers came to tears, and George Washington stopped this insurrection. Okay, so the significance of this, right, is that when they drafted the Second Amendment in 1791, again, they knew that an insurrection was possible because it had happened earlier against the or was about to happen earlier against the Continental Congress. And the solution to this was not to put exceptions in the Second Amendment. Okay, it just says shall not be infringed, which basically means no exceptions. Okay, so in fact, that's the only right that essentially says no exceptions. Okay, through shall not be infringed. Okay, now interesting. A lot of people say that this was a failed attempt, but it was actually successful because the result, okay, of this 1783 Newburgh conspiracy was that the Continental Congress heard about it and they said, okay, George Washington managed to stop them this time. He may not stop them the next time. And what they did is they actually agreed to that the soldiers would get a 5-year pension after leaving service. Okay, so this was actually successful. Okay. So the next time was a few years later, okay, in 1786. Basically, a lot of these farmers that have gone home, a lot of them, this pension that they're supposed to be getting, they haven't been getting it, and they're pissed off, and a lot of them are losing their farms, right? They're being foreclosed on. And on top of that, the state of Massachusetts is taxing them, okay? So this happened in Massachusetts. Massachusetts is taxing them, and again, they haven't been getting their pensions. So they got together to protest, and then, they decided to take it up a level, okay? And this turned into an active rebellion. The result of this was 4 people were killed, 20 wounded, and 2 were hung, okay? The 2 leaders of this were hung, which was not Shay himself. I guess this guy wasn't actually pushing. This guy was more pushing the protest rather than the armed insurrection. But most of the people, some 1,500 people, were pardoned. And again, this happened before the drafting of the Second Amendment, which was just, 5 years later. Okay, so again, when they wrote the Second Amendment, Shay's rebellion had just happened, okay, and the reaction was not to limit gun rights, right, or to ban guns or put exceptions in the Second Amendment, right? You would think that this would be like right there in their mind. It just happened 5 years earlier, okay. So again, that's why these 2 things are very significant. Now, a lot of people look at Shay's rebellion and say that it was a total failure. The rebellion was put down. But Massachusetts did actually capitulate. They did cut taxes, and they did give the soldiers more time to pay their debt. Now, as far as the pensions, I didn't read anything in regards to that. I think the way that worked is because I don't think that the United States has been formed yet, right? We're still in that constitutional era. I think that after the Constitution was drafted, the United States government basically agreed to pay the money due, the pensions. Okay, and that's actually one of the things that made the United States made it very credible early on. The fact that the United States government agreed to take on the debt that existed before its formation. So that made it very credible, instantly around the world. Okay, I want to give a thanks to Mark Smith for giving us the right way to think about it, because I don't think that, or rather the right way to think about it with regards to how the Supreme Court and judges think about it, because basically we have to be, that's what we're up against. We have to be approaching this the correct way, okay, in order to win. So I don't think that he's mentioned these 2 examples, but he's given me the information to come up with these, with these 2 examples, because he might not be, he's more interested in legal history, right? In constitutional history, but he might not be so interested in military history, which is why, as I'm these 2 things pop into my head, and hey, this is what you said. These 2 examples here fit the bill that you gave us perfectly, okay? So it's up to us to spread the news. We've got some good material here to work with. Thanks for watching. We'll give you guys a close-up with some dates and stuff over there that you can use.